Good evening, everyone, and welcome to this property law seminar, where we're going to look at the recent judgment of the UK Supreme Court in Guest and Guest, which was about the situation where A promises B that B will acquire certain rights over A's land, and then B reasonably relies on that promise about a future right in land to B's detriment. And the question is, if A later goes back on that promise, what remedy should B have? And then, broadly speaking, the choices are either that the promise should be enforced, so that's the kind of the enforcement option, or the other extreme, you might say, is that the focus should be on undoing any detriment that B might have incurred. That's broadly what Guest and Guest is about. And the significance of Guest and Guest is it's the first time that the UK Supreme Court had the opportunity to focus its thinking on that specific question and to offer guidance as to the approach to be taken. Of course, it's a UK judgment, not a Hong Kong judgment, so it's not binding here, but surely the ideas of Guest and Guest are going to be of great interest to Hong Kong audience. It's an enormous judgment. It's 105 pages, split into a majority judgment, and in a moment I'm going to hand over to Professor Stephen Gallagher to talk to us about the majority judgment, and then a minority judgment. And so when Professor Gallagher is finished, he'll hand over to me, and I'm going to talk about the minority judgment and make some kind of comparison between the two judgments. After that, Professor Gallagher will tell us about some upcoming events in the faculty. There should be some time for questions at the end of our presentations. If you've got questions at any time, could you put them into the chat box and direct them to the host, perhaps direct them to Professor Gallagher, and then we'll pick them up at the end of the presentations. If you're going to apply for CPD accreditation for this, then please make sure that the name that we can see for you is your proper name, the name that the Law Society have for you. So with that introduction, now let me hand over to Professor Gallagher.
Thank you very much, Michael. I'll just share some slides if I can. So thank you very much, and welcome everyone to this property law seminar as well. I'll be, as Michael said, looking at first of all, starting with an overview of proprietary estoppel, just a brief introduction, and then we'll move into Guest and Guest, the facts, and what the majority really were, how they came to their conclusions, how they came to their judgment as well. And then I'll hand back to Michael to talk about the minority judgments, which often, of course, the minority judgment has some very interesting aspects to it as well. So if we start with the overview of proprietary estoppel, the essential elements of proprietary estoppel have been discussed in a number of cases, and a number of judges have tried to express to us what we should be looking for, what has to be established to actually be able to take advantage of the doctrine of proprietary estoppel for someone to succeed if they are using proprietary estoppel in a claim. And of course, the first thing is that there should be some form of assurance. Again, I'll talk about that a little bit more in detail shortly, but an assurance upon which the claimant has reasonably relied in some way, that means that they have then acted to their detriment because of their reasonable reliance upon this assurance. And then because of this, the fact that they have relied, they have acted to their detriment upon an assurance by the defendant, often it would be unconscionable, therefore, for the defendant, the legal owner of property, to resile from this assurance. So we need the assurance, reasonable reliance, detriment suffered by the claimant because of this reliance, and the whole thing then making it unconscionable now for the person who's made the assurance, the legal owner of property, to resile from this. The assurance can come in a number of ways. Often there are express, very clear promises to people that they will have an interest in land, that either they will have an immediate interest in land or they will have an interest in land in the future. So sometimes very clear express promises that someone will have an interest in land. But sometimes it can be vaguer than this. And this is, again, I think, the strength of the doctrine, of the way that the courts have interpreted the doctrine. So we have this famous quote from Lord Hoffman: "It was enough that the meaning he conveyed would reasonably have understood as intended to be taken seriously as an assurance which could be relied on." So sometimes perhaps not a clear promise that someone would have an interest in land, but some things are said or some things are done by which the claimant will be led to believe that they have an interest in land. And of course, the legal owner of the property, often the defendant in these cases, has to realize that the other person believes that they will have an interest in the land, or they already have an interest in the land as well. So the assurance, however it is created, has to generate an expectation in the defendant that he would inherit the land. We're using here claimant and defendant at different times will come up in the judgments because, of course, proprietary estoppel can be both a sword and a shield. It can be used as a cause of action to actually claim an interest in land, and to defend, of course, when people are trying to take back possession of land as well. So examples of assurance. In the very famous case of Thorner and Major, here we get a nephew, David, who worked for many years, 40 years, on his uncle's farm. His uncle Peter, he went to visit him, they got on very well, and he started working on the farm. He worked there for many years. The uncle never expressly promised that he would receive the farm, but he did do various things which David said had led him to believe that he would inherit the farm. At one point, he was shown some insurance policies and led to believe that he would be the beneficiary under these, and other things that led him to believe that he would inherit the farm when his uncle was gone. And his uncle did at one point actually execute a will, which left the residue of his estate to David as well. But that will was destroyed. It wasn't clear why the will had been destroyed, and the uncle in the end died without making a will. Now, when it had to be decided whether David did have any interest in the farm, the court was quite clear that David had believed that he had an interest in the farm, that his uncle's actions had in a way been an assurance to him, which he had relied upon, and his work there without pay for 40 years, of course, was a substantial detriment, a very substantial detriment to him. And because of this, if he didn't receive the farm, of course, well, this would be unconscionable. Because of this, the court held that David was entitled to the farm, of course, subject to paying inheritance tax upon receiving the farm as well, but he was entitled to the farm. So we get these instances where the assurance may not be an express promise, but certain things are said or done which lead the other party to believe that they will have an interest in the property. Probably one of the most famous cases, which involves express promises, is another farmer case. And of course, many of the cases in England involve farmers, because often farm workers, those involved with farms, families, work for very little salaries on the farms, often with representations that they will receive an interest in the farm or a part of the farm at some time in the future. So Gillett and Holt, one of the most famous cases here. A Court of Appeal is the important decision that we usually rely on. Mr. Gillett had worked on Mr. Holt's farm for over 40 years. So again, a long-term worker on the farm. He'd met Mr. Holt when he was a young lad, had started coming to the farm, had got on very well, Mr. Holt, and started working on the farm. He had made some sacrifices in coming to work on the farm. He wasn't paid very much. He did get some benefits from working on the farm. Mr. Holt eventually bought another farm, and at one point Gillett and his wife were living in one of the farmhouses there rent-free. But Mr. Gillett got very little salary from actually working on the farm. On a number of occasions over the 40 years, over 7 occasions, Mr. Holt had promised the farm to him. And again, at one point had executed wills, which Mr. Gillett knew, which had identified Mr. Gillett as the residuary legatee, and that would include the farm. So he was to get both of the farms when Holt passed away. Unfortunately, Mr. Holt made another friend, and of course this was a friend who was made things a lot more complex because it was a young solicitor that became his new friend. And the new friend, of course, at one point said, "Why are you allowing these people to live rent-free in that farmhouse? Why are you allowing, why are you going to be giving the farms to Mr. Gillette? Why don't you give the farms to me?" Along that line. And of course, Mr. Holt listened to his new friend and asked Mr. Gillette to leave the farm and took proceedings to actually remove Mr. Gillette from the farm. Gillette counterclaimed on the basis that he had an interest in the farms under the doctrine of proprietary estoppel. The Court of Appeal confirmed that Mr. Gillette did have an interest by way of proprietary estoppel. He had been given clear promises that the farms would be his one day. He had, of course, again, suffered a substantial detriment in working for very low salary for 40 years. He had received some benefits, but on the next slide, we'll see the words of Lord Justice Robert Walker about the idea of what detriment is all about in this particular doctrine. And in the end, Mr. Holt, the Court of Appeal was quite clear that he couldn't, they wouldn't order him to transfer both the farms to Mr. Gillette. They would order him to transfer the freehold of one of the farms to Mr. Gillette, the farm that he was actually living in, and they would offer, they wanted some compensation for him not receiving the other property as well. So a payment of £100,000 was to be made to Mr. Gillette as well by Mr. Holt, because Mr. Holt would hold on to the other farm. He needed somewhere to live. Lord Justice Robert Walker explained to us a little bit about the concept of detriment. And he emphasized this: the detriment need not consist of the expenditure of money or other quantifiable financial detriment, so long as it is something substantial. The requirement must be approached as part of a broad inquiry as to whether repudiation of an assurance is or is not unconscionable in all the circumstances. So it's not just about money, and it's definitely not just a balancing exercise. Again, it was noted in Gillette and Holt that Mr. Gillette had some benefits from actually working for Mr. Holt and being in those properties for all of those years. But there had to be something important in the detriment, something substantial. And part of this, of course, was the fact that when he was a very young boy, he had given up the opportunity of staying on at school to come and work on the farm. That was one of the things that was noted in the Court of Appeal, the fact that he'd given up an opportunity as well. So detriment can take another number of forms. It's not a technical concept. It is something that has to be looked at in the particular context of the case. It could be working free of charge. It could be giving up other opportunities, and there can be benefits that the claimant or the defendant has actually had from working or relying on the assurance as well. And it's not that sort of idea of a clear financial balancing act there. So it can take a number of forms, and there can actually be benefits to the person who is trying to claim an interest by way of proprietary estoppel. In Hong Kong, we've had some interesting cases as well to do with the concept of proprietary estoppel. This is one of the most recent cases from the Court of Final Appeal in Hong Kong, the Chung Lai Mui case. Here we get three brothers, Mr. Wan, Mr. Cao, and Mr. Phuc, who were tenants in common in equal shares of a plot of land in the New Territories. They made certain statements to the third defendant involved in this particular case, who was one of the brothers' grandson, that he was to receive the land in the future. When he became an adult, he would get the land. The Court of Final Appeal and the trial judge described this as the common understanding that arose between the three brothers and the defendant as well. It was also a common understanding within the family, emphasized a number of times by the trial judge and the Court of Final Appeal, was that in this particular case, we are dealing with land in the New Territories and a very traditional Chinese family and their attitudes to land. He was, the three brothers' father had actually purchased the land, and the third defendant was the only male descendant alive. So it was very important to them, they said, that the the male descendant would get this land. So the common understanding developed, he would receive the land when he became an adult. Now, when he became an adult, he started to do some work to the land. Subsequently, one of the brothers, CUHK, died. The two other brothers supported the third defendant in making an application to be able to build a property or a small house on this particular plot of land. And he did. He built subsequently 2 large buildings on the land. But the 2 large buildings that he built on the land were actually built after the 2 surviving brothers had died. The plaintiff here was one of the brothers' daughter. She was the legal owner of her father's and her uncle's shares in the land. Of course, the third defendant, of course, had an interest by way of his father, but the actual dispute arose because the plaintiff had actually fallen out with other members of the family as well. This particular dispute arose after the original dispute that she was having with other members of the family over another plot of land. And when she did actually try to claim that the grandson should move off the plot of the land, and he counterclaimed on the basis of a proprietary estoppel, her argument was that he could not be successful by way of proprietary estoppel because he built the buildings, his detrimental reliance, if you like, upon this common understanding. This was done after all 3 of the brothers had passed away. So after the promisors had passed on, he had then done something to his detriment. And of course, it raised that issue for the Court of Final Appeal. Could you actually have a situation where you would be successful in a proprietary estoppel if the claimant actually said, well, I was made certain promises and assurance, I believed them, I relied upon them, I acted to my detriment, but it was actually after the promisors had passed away. Now, the Court of Final Appeal was quite clear, no, you couldn't do that, because the promise would have to lapse with the death of the promisors, the last of the surviving 3 brothers. At that point, then the promise would lapse at that point. So he had to have actually performed some detriment, something to his detriment before they passed away. The Court of Final Appeal was quite clear that because of the particular nature of this common understanding, because this was a Chinese traditional family in the New Territories, and because he had started to work on the land well before his uncles had passed away and his father had passed away, and of course had his uncle and his father had supported him in his application to build the properties as well, that there was detrimental reliance. The assurance was such, there was detrimental reliance, and therefore he was successful. He claimed to be the sole beneficial owner of the property, both by way of common intention constructive trust and proprietary estoppel. The Court of Final Appeal was quite clear. He succeeded in proprietary estoppel, and they told us we should not try and conflate the two, the doctrines of common intention constructive trust and proprietary estoppel. And maybe, Michael, maybe we can talk about that a little bit later on as well. But again, an interesting case with our Court of Final Appeal in Hong Kong. Now, if you are successful, we've already started to talk about some of the things that happen if you are successful in one of these cases for proprietary estoppel. We have to look at what relief you should get, and that, of course, is what Guest and Guest is all about. The traditional phrase that is used to describe what the courts can give if you're successful in proprietary estoppel claims is a minimum to satisfy the equity. The court has the discretion, and they should try to give the minimum to satisfy the equity, with the aim being, as Lord Scarman put it out, to undo the unconscionability of the fact that the promisor, the person who's given the assurance, is trying to resile from their promise of their insurance. There have been other cases where it's been said that we should start to look to fulfilling perhaps the agreement. If we've got something which is like a contract, which is almost a contract between the parties, we should look to fulfilling that. And that really is looking at the expectations of the person who has been given the assurance, fulfilling those. And then there's also been this point put forward that perhaps we need to look for some sort of proportionate response between the expectation of the person who's been given the assurance, who has relied on the assurance, and the detriment they've actually suffered as well. Do we compensate them for the detriment, or do we fulfill their expectations? Now, in all these matters, again, other judgments have noted that the party's conduct is relevant. What actually goes on, the context of the assurance being given, and then the nature of the detrimental reliance is also important as well. But there is a wide discretion. Many different remedies have been given for the successful claims for proprietary estoppel, including proprietary interests in land. When we talked about Gillette and Holt, we have a freehold being transferred, licenses, life interests, money compensation as well, again, as we saw in Gillette and Holt. So, as was said by Mr. Justice Lewis and in Davis and Davis, when the elements of a proprietary estoppel claim are established, deciding how to satisfy the equity is a retrospective exercise looking backwards from the moment when the promise falls due to be performed. In Jennings and Rice, a man looked after an elderly lady. She promised him he would inherit a substantial sum because of this, when the matter was sorted, he did succeed, but he was dissatisfied with the amount of money he was actually awarded. He appealed to try and increase the amount, and he failed. And the point was made that there must be some sort of proportionate response between the expectation of what he thought he would receive and the detriment that he's actually suffered at that point. So in cases where the assurances and the claimant's reliance on them have a consensual character, falling not far short of an enforceable contract, well, then we will, of course, look to perhaps enforce the contract between them. Another case where this matter was considered is the case of Suggett and Suggett. And in Suggett and Suggett, we have another farming case. The son here was not possibly the best farmer in the world. There were lots of problems with him actually being a father. He wasn't very diligent in his work there. But his father had promised him that if he went to agricultural college, if he worked on the farm, then he would receive the farm in the future. The father did support the son. He did provide him money as well. But eventually, when he died, he left the farm to his daughter. The son applied to the court for the award of the farm. He said, I was promised the farm. I fulfilled my father's wishes. He assured me I would get the farm if I went to agricultural college, if I did various things. So I should get the farm. And the court had to consider this in the circumstances with the detriment that the son had actually suffered, and possibly considering other parties, the daughter as well, would it be excessive to award the farm to the son? We'll come back to that a little bit later on. So let's think a little bit about guest and guest and what actually happened there. So again, we've got another farming case. The father promised to leave his son enough of his farm to form a viable farming business, and in return, the son worked on the farm at a low wage for many years. He had opportunities to pursue alternative careers, and he did not pursue them. At trial, because he wasn't left he had fallen out with his parents. So because he'd fallen out with his parents, he made a claim while his parents were still alive to actually take the farm from them, to fulfill the promise that they'd made to him. At trial, he was awarded 50% of the market value of the farming business and 40% of the market value of the farm itself. The Supreme Court, though, when it considered this, said this wasn't really a fair outcome. Why? Because to actually fulfill this, to actually fulfill the award made by the trial judge, the parents would have to sell the farm immediately to pay the son. And also, the son would be getting this 50% of the market value of the farming business, 40% of the market value of the farm early, because he was meant to get it when his parents passed away. And of course, he did not. So the Supreme Court said in those circumstances, the best way to approach this was to actually give an option to the parents to decide how they should remedy the situation. And the option was between this. They could set up a trust of the farm, which meant it was for the parents for life, and then the son would get the first instance award when they passed away. Or they could get the first instant, they could pay the first instant award to the son now, but give a discount for early receipt of the son. Now, the majority judgment, the central features of this were emphasis upon what the purpose of proprietary estoppel is. Lord Briggs noted it is neither an expectation fulfillment nor detriment compensation. That's not the aim of the remedy. The aim remains what it has always been, namely the prevention or undoing of unconscionable conduct. So that idea of, are we fulfilling the expectation? Are we compensating for the detriment? They said, no, it's all about just undoing the unconscionable conduct. They also talked a little bit more about that idea of the expectation or detriment was the guiding principle. You know, his expectation was that he would get enough of the farm to carry on the business, so a share of the farm. The detriment would be compensation for the fact that he had not been paid to actually do the work. So we've got to think between the two. They highlighted some of the considerations that should be made when designing an order for relief. They said that review of the authorities suggested that fulfilling expectations was the norm, but there should be proportionality to do with the detriment with regard to what the person who's been given the assurance has studied. This had become more of an important factor in recent judgments. Other factors may be relevant to the question of a just outcome in a particular case. For example, things as in this case with early receipt or other claims on the person who gave the assurance. And again, it can take us back to other cases where there are other children who maybe would receive some of the property as well. So the principles they highlighted included this. The court should decide whether repudiation of the promise is unconscionable in the circumstances. They should start with the assumption that the appropriate relief is full performance of the promise or a monetary equivalent, but be aware that there may be factors which would render this disproportionate. The burden of proof is on the party arguing that full performance is disproportionate to actually move away from this, and full performance is likely to be appropriate in cases that fall short of a contract. So again, they're bringing all of those things that have come from previous important judges to us as well. We should also note that just because full specific performance is inappropriate does not mean that detriment should be taken as the yardstick. We should still look at the expectations under the particular promise. In the end, it was said the court will have to consider its provisional remedy in the round against all the relevant circumstances and ask itself whether it causes injustice to third parties as well. So very much that sort of idea of a remedial approach to this. They also noted this, duration could be a factor, how long the detriment was actually going on for as well. If we're focusing on the detriment, where the detriment is specific and short-lived, and in particular shorter than the parties are likely to have contemplated, that could be taken into account. But wherever the relevant detriment has, as in this particular case, had lifelong consequences, a detrimental valuation analysis will fall upon stony ground. You have to look at the fact that this has had such a long-term impact upon the person who's been given the assurance here, the son. So going back to Suggett and Suggett, as I said before, the father had promised to leave the farm to his son if his son went to agricultural college, if he worked on the farm and other things. He gave him money and supported it. He gave him other benefits as well. He allowed him to keep his own small beef herd of cattle as well. But in the end, he left the farm to his daughter. The son makes application to get the farm, and the court has to consider whether it's excessive to award the farm to the son, or should he have received a cash award for his services instead. In the end, Lady Justice Arden noted that to have given him a cash sum would have done the minimum, but it would not have done justice to the claimant given the assurances he had been given and is acting to his detriment. So the court awarded him the farmland and a house, and his sister, who of course had been left the farm by the father, she was given one of the other houses and she was given the father's monies. So they tried to deal with taking into account the effect on the sister as well. We've also had the case of Lydon and Burton as well. This involved a married man who formed a relationship with a lady while he was out in Sweden. They lived there for a number of years in a rented property. The man then got divorced, and as part of the divorce, he bought out his wife from a property that they had jointly owned in England. The couple then went back to England, And on a number of occasions, Mr. Burton promised Mrs. Lydon that he would look after her forever. They went back to live in the house in England together. And after a while, Mr. Burton, because he was worried about his finances, asked her for a contribution towards mortgage payments, although he never completely revealed his finances to do with the property. In fact, when Miss Lydon asked him a couple of times, what was going on with the property and what was the money for, and she paid him a substantial amount of her money. She was receiving a pension at the time from the Swedish government for an injury she'd suffered. She was paying over about 50% of that to him. She said, "What's it for?" He said, "These are just payments towards the house." And he said that on a number of occasions as well. They lived together in the property for 12 years. And when the relationship broke down, she claimed an interest in the property. The court, when it had to decide what she was to receive, awarded her a money payment. They considered the money that she'd actually paid towards the property. At the time of the relationship of the court hearing, the property was worth about £435,000. It had a mortgage on it of about £98,000. But the court really focused there on the amount that she had actually been paying towards it. And they worked out the payments that she'd actually made over the years, and then ordered that Mr. Burton should pay that back to her, of course, with interest. She received some, I think, £33,000 at that point. So in Guest and Guest, we've had another consideration about how we should approach this from the majority. They noticed that in this particular case that we're talking about, the effect was such upon the son that there should be there should be more than just a money payment to him. In a case like the present, of course, in the end, he did get a money sum awarded, but it had to be substantial. Lord Briggs noting, in a case like the present, the harm consists of the soul-destroying, gut-wrenching realization of being deprived and then actually being deprived over the rest of a lifetime of an expected inheritance of land upon which the promisee has spent the whole of his life and worked to date, and which in due course he expected to be able to pass on to one or more of his own children, making the same promise to them as his father made to him. This cannot necessarily be valued with any reliability. So that's the comment that's made, even though, of course, in the end, they are saying to the parents, you've got the choice. Either you set up the trust, or you can make an accelerated and early payment on this. So with that, I'll hand over to Michael. I'll stop sharing and hand over to Michael to tell you about the minority, the interesting comments of the minority in this case. Michael.
Thank you, Steve. So the judgment in Guest and Guest is an enormous judgment. It's 106 pages. The majority judgment that Steve has just described to you, is 41 of those 106. So the remaining 67, is it 67? Yeah, 65. So a much larger part of the judgment is the minority judgment. It arose really because counsel for the parents in Guest and Guest specifically invited the Supreme Court to set out the principles and to say whether an expectation or a detriment approach was more appropriate. So in this part, where I'm going to talk about the minority judgment, first of all, I'm going to say what the difference in outcome was as between the majority and the minority, and then to say that the minority looked at proprietary estoppel in a different way, and just like the majority, they look back over the development of proprietary estoppel, but really from a different perspective. And just like the majority sets out a framework or statement of principles to be applied when calculating equitable relief, so too does the minorities first of all explain the elements of its reasoning and then kind of crystallize that in a statement of principles. So I'll explain what that framework looks like and then how it applied to the facts of Guest and Guest. Specifically as well, I'm going to talk about how the minority thought about emotional harm. We've just heard that Lord Briggs thought that the emotional harm was incalculable, but we'll see that the minority differ in that. They think the emotional harm could be calculate it. You could assign a money value to it. And I've got a table then comparing what I think are the essential similarities and differences between the majority and minority approaches. And then to say why I think it's helpful that we've had this minority judgment. And then we'll close, and that should leave some time for Q&A. So in terms of differences in outcome, we heard that the majority thought the appropriate course of action was to enforce the promise, or to give a sum of money that would represent enforcement of the promise. And that amounts to 1.3 million, less a deduction for the value of the parent's life interest. Whereas the minority came to a very different figure of 610,000. The minority looked much more at the detriment, and saw the detriment as being the lost earnings, the difference between the earnings that the son got on the farm versus what he would have earned if he'd gone to find a job in the open market. So that very different approach to calculating the relief. As I said, the minority really looked at the proprietary estoppel authorities in a very different way. And what they say is that for a long time, proprietary estoppel was a genuine estoppel. So in the sense that A was stopped from enforcing existing rights against B because of some promise that had been detrimentally relied upon. Perhaps was stopped from relying on some lack of formality, from some failure to satisfy a registration requirement. But it was an estoppel, purely defensive, and so leading to kind of binary outcome. Either A was stopped or was not stopped. But the minority point to Proprietary District Council as a kind of a watershed moment in the development of the law of proprietary estoppel. Because they say Proprietary District Council marked the beginning of a new type of estoppel, where A's promise creates new rights. In Proprietary District Council, the promise of a grant of an easement, of a right of way. So they see that as the beginning of a new type of estoppel. And then they say that Thorner and Major, which Steve's already described, is important because it describes the essential features of this new type of estoppel. So whereas the majority, of course, had said, yes, this is this case is what's important to note is it's about a promise of a future right, but they thought that was essentially just one fell within the broad family of proprietary estoppel. Whereas the minority say that this type of estoppel is so different in the sense that it's a promise giving rise to new rights, that we should see it as being a different thing with a different name, property expectation claim. They say that whether action or inaction in reliance on the promise constitutes a detriment depends on what the claimant would otherwise have done. So that in this judgment, what the minority says is, well, if the son had not received the promise, what would he have done? Well, he would probably have gone and got a better paid job in the same line of work. And then the reliance loss, the extent measured in money to which the claimant is worse off as a result of relying on the promise. So they say, well, let's calculate what he would have earned and compare that with what he actually did earn whilst working on the farm. And the difference would be the reliance loss. So just like the majority, the minority sets out a statement of principles, a kind of a stage-by-stage guide to thinking about equitable relief. And before getting to that, let me just sort of point to some of the things they said leading up to that. First of all, the minority says, whereas Lord Briggs in the majority judgment had said that the purpose of proprietary estoppel is to undo unconscionability. But of course, the minority would agree with that, but they phrase it differently to say that the equity is to be protected from detriment that will suffer if the promise is not kept. So it's a different focus, isn't it? That undoing unconscionability involves protecting B from detriment. So a clear focus on detriment as the point of proprietary estoppel, protection from detriment. Like the majority, they make the point that there are two ways in which this protection from detriment could be achieved. One way would indeed be to enforce the promise, as the majority did in this case, or the alternative is to is to give B, is to undo the detriment, is to give back to B the reliance loss. So kind of it's not quite a binary, but it's closer to a binary than the majority decision. How should we decide which to do? So and what Lord Stevens, Lord Leggett and Lord Stevens, the majority judges, say is that we should think about, well, what is the point of proprietary estoppel? It's to undo detriment. That's the underlying purpose of proprietary estoppel. So doing justice to the defendant requires that the court should not award a remedy which is more generous to the claimant and more burdensome for the defendant than is necessary to achieve the underlying purpose. So, undo the detriment, but no more. A few other points, the sort of factors that lead up to this, the statement of principles that I'm going to describe in a moment. So the aim is to award a sum which we have perceived as fairly reflecting the gravity of the injury. Monetary compensation to undo detriment is the main aim. But sometimes, the second bullet point here, sometimes it may not be possible to quantify the detriment. And that might be a reason to enforce the promise. But what we're going to see is that the minority are much less willing than the majority to think that detriment is incalculable. I'll come back to that. And anyway, even if you do enforce the promise, because of different quantification, still the award mustn't be out of proportion to the detriment. As Steve has said, and as the majority also said, that when you've got cases that are something like a contract, if you look after me for the rest of my life, you would inherit my property, then we don't need to think about the question of proportionality. The parties have already said that the detriment, that the expectation is proportionate to the detriment. But the minority said that whereas here the case involves family members, then it's very unlikely that it's something like a contract case, because when the relationship is where the relationship is a family relationship, other factors are likely to come into play, other considerations than purely bargain-like considerations. I'm going to leave the last bullet point because I pick it up in this next slide. They point out as well a factor that that some things to be borne in mind when we think about assurances and promises, and that is that they may be subject to unspoken qualifications. So, of course, well, if the promise is, if I say I'm going to leave the property to you when I die, then of course it's subject to the very spoken qualification that it's conditional on my death. You won't get it now, you'll get it when I die, and we need to think about that. Or it may be that the unspoken qualification is that I will leave this property to you so long as the relationship between us remains in good order. But if the relationship breaks down, then the promise is kind of null and void. And so that might be a factor. And what the minority say there, then Lord Leggett and Lord Stevens, is that if these unspoken qualifications are not satisfied, then that could militate against enforcing the promise as being the appropriate response. This is a very interesting idea, and let's see if it's taken up. So let's suppose that A says to B that he promises B that sometime in the future, B will be given certain rights in A's land. B detrimentally relies on that promise, so the essential elements of proprietary estoppel are made out. But then A changes his mind, decides that he doesn't want to fulfill the promise. And the suggestion made by the minority is that what A can do in this situation is to make a remedial offer to B. And Lord Leggett says this: it seems to me that provided the prospective benefactor has endeavoured to treat the promisee fairly and has made a genuine and reasonable alternative arrangement or offer of amends, a court should be slow to find fault with it and to order more extensive relief. So, of course, this is in the minority judgment, but it is an interesting idea that A can make this offer, and if it's a reasonable offer, then B will have to think very carefully about rejecting it, because if he rejects it, you may find that the court says, well, we're not going to give you any more, and it may well have consequences. So now finally, not finally, now we've come to the stage of comparing the two frameworks. This is the slide that Steve presented to you before, the framework or statement of principles from the majority judgment, where first of all you say, well, is repudiation of the promise unconscionable? If it is, then what should be the relief? The second point here, the strong assumption is that the relief should take the form of enforcement of the promise or its monetary equivalent, provided this is not obviously disproportionate with point 3, with the burden of proof being on the person who's asserting that the enforcement is disproportionate. Full performance of the promise is likely to be appropriate in case of Jennings and Rice, in cases that fall just short of a contract, where I say, if you look after me for the rest of my life, I will leave you my property, and you do look after me for the rest of my life, and then I die, but leave the property somewhere else. Then we could say that we've already agreed that getting the property is the proportionate response. But the majority said that if you decide for some reason that full performance is not appropriate, this is point 5, then that doesn't automatically mean that we move over to quantifying detriment and giving you your detriment. And I think this is not quite the line of the minority. So now let me show you the minority statement of principles. The majority said, Lord Briggs said, the core aim of proprietary estoppel is to undo unconscionability. Lord Leggett says, no, it's preventing detriment, which of course in the end is to do with unconscionability. This could be done in either by enforcing a promise or by giving money to compensate for the reliance loss. But there's no, unlike the majority, there's no strong starting point of enforcing the promise. But in the third point, there is a situation where enforcing the promise may be appropriate, will often be appropriate. And that's where the date for performance of the promise has passed, reliance loss is difficult to quantify, and enforcement is not clearly disproportionate to the reliance loss. So enforcement of the promise is possible, but it's not the starting point. And then item 4 is back to this idea of the remedial offer. So if A withdraws the promise before the performance date, but makes a fair offer for compensation, then relief should rarely exceed the offer. So B would have to be cautious about rejecting that offer. A, because he's on warning, he's unlikely to get more, and B, then his rejection of the offer may well have consequences. But otherwise, the court's got to decide which is it, enforcement or reliance loss. So those are the principles. How do they apply to the facts of this case? So Lord Leggett said, well, should we enforce the promise? Which is one way we could undo the detriment. And he said, actually, it would not be possible to enforce the promise. The first bullet point here, what was the promise? The promise was that the son would receive enough land to set up a viable farming business. But the land that he was set to receive, 50%, I think, of the farming business, 40% of the freehold, value of the freehold, Lord Leggett said he doubted whether it would be possible to set up a viable farming business on such a small area of land, so that you wouldn't, so that the majority award does not actually amount to an enforcement of the promise. An enforcement of the promise is neither possible nor desirable, probably for the son. He probably wouldn't even want at this stage in his life to set up a new farming business. He was already in his mid-50s. So the minority said, in fact, there's no choice. The only thing we can do is to come up with a monetary award to compensate for the reliance loss, which is the difference between what he would have earned if he found a job on the open market versus what he earned working on the farm. And this is good because instead of having to think, well, what might have happened? What if the parents had needed the land needed to sell the land because of ill health or whatever. There's no need to think about those possibilities. It's entirely backward looking. What is the loss of wages historically? And the penultimate bullet point, that is the measure, the difference between the wages he would have received had he worked at a market rate versus what he received. I also think, although this is a point that's not made by Lord Leggett, that principle 3 from the minority framework might be relevant. Just putting up again the slide for the minority framework, and I put in bold principle 3. Enforcement will be appropriate where date for the performance has passed. But this was not true in this case. The date for performance was still in the future when the parents died. And where reliance loss is difficult to quantify. Now, Lord Briggs in the minority said that the reliance loss was difficult to quantify, but the minority disagreed. They were much more optimistic about the ability of courts to put a money figure even on emotional loss, harm. So the parties begged the Supreme Court not to leave the matter unfinished, not to remit the case back to a first instance court because of the extra cost and expense. So the Supreme Court said, okay, so we've got to decide what is the right award. We've heard already what the majority approach was. The minority approach was set out in appendix. The workings are set out in appendix to the minority judgment, where they work out what the son actually earned working for his fathers in the parents' business on the farm, what he would have earned if he'd been paid at the market rate for the same work, and then the reliance loss was the difference. And that led to the award, that plus interest led to the award of £610,000. But one thing to point out is how the minority thought about emotional harm. Lord Briggs and the majority thought that, as Steve showed a slide with a quote about this, said that this was incalculable harm, lifelong consequences, and the minority acknowledged this is true. There was emotional harm that arose from having built his life on the expectation of inheriting Trump Farm and then seeing that disappointed. And the first bullet point here, they said, we think that it is possible to award compensation for that disappointment and distress. And we think about how courts work in tort cases, for example, that it would be possible to put a money figure on this. It's not incalculable. So I think that's a very important difference between the majority and the minority. They decided, in fact, in the end, that they weren't going to give any money for this. First of all, because they thought that whereas it would be legitimate to give compensation for feelings of dislocation and distress, and having to rebuild his life having to rebuild his life, that couldn't be separated from, the anger and sense of betrayal, which is not something for which compensation can be given. They also said that they didn't feel, as the Supreme Court, now having heard the evidence in the same way the first instance judge had, they didn't feel well placed to assess this aspect of the matter. And anyway, they said, if he's 610,000 should go a long way to help him get over his hurt feelings. So now a little table where I tried to set out what's in common and what's different between the majority and minority judgment. So first of all, the aim of proprietary estoppel. The majority said it's to prevent unconscionability. Lord Leggett said that the English law can do better than that. And he says that's true, but specifically it involves protecting from detriment, ensuing from reasonable reliance on a promise. When is the second item? When is the appropriate award enforcement of the promise? For the majority, that is the starting point. And you keep an eye on detriment and the possibility of disproportionality, but fundamentally the focus is on enforcing the promise. Whereas for the minority, enforcing the promise is just one possibility, one that's most likely to be appropriate, factor 3, principle 3, where date for performance of the promise is passed, and where reliance loss is difficult to qualify, not clearly disproportionate. What the two judgments have in common, the third line, is that the award should not be disproportionate. They both accept that after Jennings and Rice, there is a need to bear in mind this issue of proportionality. But again, where there's a difference, and I think this may go a long way to accounting for the very different outcomes, whereas the majority thought that the kind of lifelong, very emotional consequences of this repudiation were incalculable, not possible to put a money figure on the reliance loss. The minority thought, well, we can compensate for it, but we can also put a money figure on it. We can calculate it. It's not incalculable. So there's no reason to favour enforcement of the promise. Some people thought it was a bit strange that we've got why have a majority and minority judgment? Well, the most obvious reason is because the minority didn't agree with the majority. But I think there are other sort of side benefits, if you like. And first of all, having these two judgments for us as law teachers and so on, and lawyers, it's just helpful it helps us to see in a more practical way what's the difference between an enforcement biased approach and a detriment biased approach. And also, I think that seeing the choices that the minority make in their judgment brings into clearer relief the choices that the majority made. So it sheds light on the majority judgment. And finally, just because the minority judgment is the minority judgment doesn't mean to say that the ideas in it and the reasoning in it are of no value. Some ideas in the minority judgment may come to be influential. For instance, that concept of the remedial offer might well be developed as a useful tool. Just some reading. Both the majority and minority, of course, review the most important English and Australian case law, but also draw extensively on academic literature. I just want to point out 3 bits of literature. Professor Martin Dixon of Cambridge University, an editor of the Conveyancer and Property Lawyer, is probably written almost the only academic piece to emerge after Guest. It's reading Guest and the law of proprietary estoppel. And he describes the majority judgment as pragmatic, rather than involving any kind of search for principle. And he wonders whether that's a good thing. In an article that's slightly earlier in 2002, that slightly predates the judgment, he describes the law of proprietary estoppel as being like a piece of modern art, like a Jackson Pollock, a splattering of unpredictable colour on a canvas, where a sense of objective form and predictability has been lost. On the other hand, he notes that proprietary estoppel has the benefits of flexibility as compared, for example, with the common intention constructive trust. But is that flexibility at the cost of uncertainty and unpredictability? Now, Professor Ying-Kai Yu from Melbourne University, he's cited by Lord Leggatt, this article in the Oxford Journal of Legal Studies, and he says that he's commenting on the Australian approach. And he says, well, the Australian courts have come to have a kind of starting presumption of enforcement of the promise as being the appropriate relief. But that doesn't mean to say that the underlying purpose of proprietary estoppel isn't to undo detriment. So he doesn't think those two things are incompatible. And I want to give a shout out to Ying-Kai Yu, because hopefully he's going to give the next seminar in our series. So that's all I've got to say. We may have a minute or two for questions.
Thank you very much, Michael. Yeah, I think we've got about a minute or so, but we can probably just raise a couple of points. We've had a couple of questions coming in. Apologies that we can't go through all of them. Your point about the importance of the minority judgment. I think minority judgments have always been important in the development of the common law anyway. Lord Gough was a great in favour of all judges to give their judgments down to the minutest little difference between them. He said this would be important in developing the common law in the future. So for our purposes tonight, though, just to go back to part of what you were saying, and something that came from the majority and the minority, is I think the noting that with proprietary estoppel, you can take account of the effect on third parties. And I mean, do you think this is an important difference with the common intention constructive trust, at least at the way we're meant to look at common intention constructive trusts?
Sure. So I suppose the idea is that, and the Chumlai Moy case, that's an example. That both common intention constructive trust and proprietary estoppel were raised, because so there often is that choice. And the thing is, common intention constructive trust is institutional. So the idea is that typically that once property is acquired, which is subject to the trust is normally thought to arise on acquisition and to be proprietary. And therefore, it's not possible to, in theory, to adjust the proportionate ownership to take account of doing justice to third parties. But as you say, and Lord Leggett really emphasises, part of doing justice is doing justice to the defendant, but also maybe not necessarily to do justice to the third parties. In Guest and Guest, there's need to do justice to the younger son Ross as well. So yes, absolutely.
And again, that sort of feeds into noting the differences in some of these cases, which again, I think was noted by both the majority and the minority, that, for example, in Guest and Guest, in Gillette and Holt, we're talking about promises about some future interest, and the court has got to consider them there. So, and that is the distinctive feature of Guest and Guest. So both the majority and the minority say, yes, we acknowledge that this is unlike cases where B already thinks he's got a right over A's land because of A's encouragement. That this is the Guest and Guest is about the different situation where A promises B that he will in the future acquire some right. But so yeah, that definitely is a difference. Of course, the minority think that that's such a difference that we should give it a whole new label and let it develop a life of its own. Yes, interesting. Hopefully we'll see some consideration by our Court of Final Appeal. But again, noting the decision of the Court of Final Appeal in the case that we mentioned earlier, again, that emphasis that we've got very different doctrines with the common intention constructive trust and proprietary estoppel. I think it's something we...
Can I raise something, Steve? I had a question in the chat box from Shmuel Yerushalmi,
sure.
who's a kind of a regular participant here. He's had to go to another meeting, but he asked this question. He said, does proprietary estoppel, has it got the potential to harm markets, the operation of markets? And my answer to that would be yes, it has got that potential, because the start of Lord Leggett's judgment is to say, the problem with proprietary estoppel in cases like Guest and Guest is you're enforcing promises that should have been enshrined in a contract, with all the writing and the certainty that comes with that. So proprietary estoppel does undermine the need to observe formalities, does undermine certainty, and in that sense could be said to threaten land ownership, certainty of land ownership, and therefore the operation of the property market. And as I said to Shmuel, the thing is though that really, we looked at this in a previous seminar, the courts have had to really think hard, therefore, about when is that risk at its greatest, and then have come up with a variety of approaches to try to balance that risk.
Great, thank you very much, Michael. I think we better draw it to an end there. So thank you once again, Michael, especially because this was your idea, I'm sure. We discussed this earlier, but I'm sure this seminar was your idea. And I think it's a great seminar topic, as we can see, having so many people join us today. The other thing is I'd like to refer everyone to Michael's Hong Kong landlord blog as well, because of course Michael has blogged about Guest and Guest on there, and there's lots about other cases. All the other cases I think we mentioned today are there on about proprietary estoppel as well. So it's a great resource. The Hong Kong landlord blog, if you Google for it, you find it very easily. If you Google about any sort of recent Hong Kong case as well to do with property law generally, I think you usually find it. So let me recommend Michael's blog to you. And again, thank you for this. I think we've got, just let me check and think. No, that's it.
Upcoming events, Steve?
I just wanted to check if there was another question, because I saw one coming in, but just in case, but it wasn't. So apart from that, we need to promote the upcoming events So Jay is showing us now. The next property law seminar is me, unfortunately. So I'm going to be talking about the origins of where trusts come from. I'm afraid it's a bit of a sort of legal history thing, but hopefully there is something of interest to everyone there. It does involve talking about the Knights Templar. I do realize that whenever you mention the Knights Templar, people tend to smile. People who understand about the Knights Templar, this very strange monastic order, warrior monks, as they're often referred to as well. But it's just because of some research that I've been doing in England, looking into old documents in England, and I think there may be an influence of them on the development of the common law trust. So I'll talk generally about the origins and then move on. That's on the 1st of March. And then, Jay, I think we've got, the WSA Now Transnational Legal History Group that talks what makes a global classic of international law. That's on the 31st of January. And then from the Centre for Legal Innovation and Digital Society, lawyer against bot. So I think this is probably important to all of us if we're worried about being replaced by these chatbots or whatever else. So how is technology impacting the legal industry and what's next? That's on the 3rd of February. And I think the final one we've got to look at is this one, which is from our Environmental, Energy and Climate Law cluster, enforcing the rights of river persons, the challenges of giving force and effect to legal personhood, and that's on the 6th of February. So I think we've gone across a range of different topics there. There's possibly something for everyone in the future. So please join us at these future events. Join us at our future property law seminars as well. Thank you very much for coming along and joining us today. Lovely to see so many old friends and also to see some new people joining in with us as well. Thank you very much to our colleagues, to Jay and Ellen, for their support in this as well. And apart from that, we look forward to seeing you in the future. We are CUHK Law. Bye-bye.